Hi, my name is Jenna DeRozier, and in this presentation, I will discuss issues in my role as a prosecutor with the District Attorney's Office. The Los Angeles County District Attorney's Office is committed to protecting the community through the fair and ethical pursuit of justice and the safeguarding of crime victims' rights. As a prosecutor with this office, my main objective is to protect the members of Los Angeles County by successfully prosecuting violent and dangerous criminals. In doing so, my goal is to maintain public safety and seek justice. It is also important to my office that we provide assistance to victims of crime and provide the community with helpful resources. Later on in this presentation, I will go over a few resources that my office provides to the community. As the largest local prosecutorial office in the United States, the Los Angeles District Attorney's Office is comprised of almost 1,000 attorneys. Each attorney's caseload is very full each year, with this office prosecuting more than 71,000 serious felonies and around 112,000 misdemeanors annually. This office strives to vigorously, effectively, and fairly prosecute all those who break the law within Los Angeles County, and see that those convicted are appropriately punished. We must successfully prosecute violent and dangerous criminals such as murderers, rapists, gang members, child abusers, and robbers. The District Attorney's Office receives funding from Los Angeles County. Each year, a budget proposal is submitted to the CEO of the county for review and approval. After that proposal has been reviewed, the proposal is then submitted to a board of supervisors. That board then holds a public meeting on the budget where they invite local residents and stakeholders to express comments and concerns on the budget. For the 2017-2018 budget, public protection comprised 26% of the $31.6 billion budget. The year prior, the district attorney's costs were around $147.1 million. Although the majority of the district attorney's office budget goes towards staffing costs, a significant amount goes towards strategic planning and programs for the community, over $40 million. To get a better understanding of how large the district attorney's office is, here is an organizational chart. The head of our department is District Attorney Jackie Lacey. In order to enter into her position, one must be elected on a 4-year basis. To become a prosecutor, there is an application process and examination that must be completed in order to be considered. As you can see in the lower parts of the branches, there are specialized units. Prosecutors are assigned to these specialized units so that they can focus on specific crimes such as gangs, police corruption, organized crime, family violence, hate crimes, elder abuse, consumer fraud, and other high-impact crimes. Being a prosecutor comes with a lot of responsibility and power. Just like police officers, prosecutors use their discretion to make decisions. They must thoroughly review all cases and determine if the evidence presented is strong enough to prosecute the case. If the evidence is strong, the prosecutor will accept the matter and either try the case or engage in plea bargaining. If the evidence is weak, the prosecutor may reject the matter completely. For those matters that move forward to trial or plea bargaining, the prosecutor will determine what charges to file, and once an offender is found guilty, the prosecutor will provide a recommendation for sentencing. Plea bargaining is where the prosecutor and defendant work out an agreement where the defendant pleads guilty in exchange for a reduced charge or a lesser sentence. The prosecutor determines the plea deal terms. However, the defendant has the ability to accept or reject the offer. If the defendant rejects the offer, the case moves to trial. If the plea is accepted, then the matter has been resolved and trial is avoided. Although all individuals accused of crime have the right to a trial under the Sixth Amendment, almost all defendants waive their rights, with 95% of all cases being resolved through plea bargaining. The prosecutor can offer different terms in their plea bargaining. In sentence bargaining, the prosecutor will offer a more lenient sentence in exchange for a guilty plea, whereas in charge bargaining, the defendant will plead to a less serious crime. Although the pleas must be approved by the judge before they are final, it is very rare that the judge does not accept the terms of the agreement. Plea bargaining presents several pros and cons. The pros of plea bargaining are that it saves costly court resources and time. It secures a guilty verdict, which eliminates the risk of trial and helps to reduce caseloads. On the other hand, it forces defendants to waive their constitutional rights. Innocent individuals may be coerced into pleading guilty. Lighter punishments for those who are guilty, which begs the question, is justice being undermined? And also, there is little prosecutorial oversight. One of the major issues with the role of a prosecutor is that they are perceived to have too much power. Let's look at this issue because it is complicated and multidimensional. As we know, prosecutors decide whether or not to bring charges against a defendant. They choose what the charges will be, they recommend sentencing, and they structure the terms of a plea deal. Because almost all cases are resolved through plea bargaining, many believe that the prosecutors control the criminal justice system, and this suggests a shift in prosecutorial authority from the judge to the prosecutor, which makes it a system of pleas rather than trials. Because these decisions are made behind closed doors, many argue that the authority of the prosecutor lacks transparency. Some of the issues are, is justice being served with plea bargaining? First, plea bargaining allows defendants to plead to lesser crimes and receive lighter sentences. This may cause additional pain to victims knowing that their offender received a lighter punishment. Additionally, this may send the message to criminals that even if they get caught, the system will most likely go easy on them. Next, the prosecutor determines the sentence and the punishment of the offender. Plea deals can vary, and because the prosecutor uses their discretion, there may be sentencing or charge disparities, and there is also an issue of racial disparity. Third, the motivation behind plea bargaining is also called into question. Do prosecutors push for plea deals because it lightens their caseload? And if so, should that be the driving force behind pleas? Prosecutors may push for plea deals solely to avoid trial because they have a very busy caseload. Also, for innocent individuals, when they are faced with the potential of a very hefty sentence, they may be more likely to accept a plea deal even if they are innocent. Those who accept a plea deal also waive their rights to due process, rights against self-incrimination, and their right to appeal. Lastly, there is an issue regarding the belief that prosecutors have unregulated power to negotiate plea deals and do so behind closed doors. Plea negotiations happen between the prosecutor and the defense counsel without judicial oversight, or very little. Once the parties agree to the terms, the deal is presented to the judge, and the judge typically approves it. Overall, these issues call for regulation and oversight of prosecutors and plea bargaining procedures. There have been several Supreme Court decisions which have established some guidelines with plea bargaining, but these aim to provide additional protections for the defendants. First, in Lafler v. Cooper, the court ruled that if a plea deal is rejected based on the advice of legal counsel, and the defendant is subsequently convicted and sentenced to a harsher punishment, then the defendant may request that the sentence be overturned and the original plea deal be offered. In essence, this decision protects the defendant against ineffective defense counsel. Second, in Missouri v. Fry, the court again established protections against ineffective counsel, in that defense counsel must convey the plea offer to their clients. Lastly, as established in Padilla v. Kentucky, defense counsel is required to inform their client that entering into a plea deal of guilty will carry the risk of deportation. These Supreme Court decisions work to balance the power between both sides by providing protections against ineffective counsel. However, They do nothing to regulate the negotiating power of the prosecutor or provide for judicial oversight of plea deals. Rather, in Bordenkercher v. Hayes, the Supreme Court gave more negotiating power to the prosecutor by ruling that the prosecutor is allowed to threaten defendants with much harsher consequences should they refuse to accept a plea deal. With that, one may wonder if we should consider abolishing plea bargaining or reforming it to deal with these issues. From a prosecutor's standpoint, plea bargaining is a necessary function of the criminal justice system. It is necessary to reduce costs and save court resources. Prosecutors have a very large caseload each year, and plea bargaining allows them to punish guilty offenders quickly so that they can focus their attention on more serious and violent matters. Additionally, when going to trial, the prosecution team runs the risk of receiving a not guilty verdict. As a prosecutor, it is more important to eliminate risks and ensure that offenders are punished even if that means a reduced sentence or charge. Ultimately, from the role of a prosecutor, we base the success of the policy off its ability to allow prosecutors to meet their goal of protecting the community and prosecuting violent and serious offenders. Thus, from the standpoint of a district attorney prosecutor, plea bargaining supports this goal. As I mentioned earlier, here are some of the programs established by the Los Angeles District Attorney's Office. Project LEAD is an educational program where prosecutors, investigators, and other legal professionals volunteer with the youth and community to teach them about the consequences of juvenile crimes. By teaching children that their decisions can have major impacts on their lives forever, this program encourages them to stay in school and stay out of trouble. Fraud alerts are sent twice a month to members of the community to help safeguard senior citizens from fraud schemes. These alerts help to educate and protect seniors from scams that aim to target them. The Abolish Chronic Truancy program, also known as ACT, works with schools, teachers, parents, and students to eliminate issues regarding truancy. Maintaining children's attendance at school can ensure that they receive the education that they need. The Juvenile Offender Intervention Network, also known as JOIN, is a program that provides juvenile offenders with alternatives to juvenile court. This program seeks to target the causation of delinquent behaviors in juveniles and aims to deter future criminality. Another program that I think is worth mentioning is the Criminal Justice Institute, which provides training to prosecutors and law enforcement regarding specific issues in the community such as mental health, gang activity, consumer fraud, and child abuse. These issues are extremely important to the DA's office, and by providing training on them, the criminal justice system can be better prepared to effectively address these issues. As we can see from this presentation, the role of a prosecutor with the district attorney's office is very complex, and they have a high volume workload. It is important to note that the district attorney's office not only prosecutes criminals and protects the community, but they also provide very important programs to the community, which shows just how important the safety and well-being of the community is to this organization. Overall, the district attorney's office is committed to protecting the community and holding offenders accountable. With that being said, I think there are a few important questions for you to consider. First, can justice be served through the use of plea bargaining? Should plea bargaining be restructured or eliminated? Do prosecutors have too much power? And I think there is one really important thing to look at, and that is deterrence. Does plea bargaining deter criminals from committing future crime, or does it have the opposite effect, where offenders know that they can plea and they can escape the full force of the law?